Buenas tardes a todos, ¿cómo están? Un gusto tenerlos. Esperamos que se vayan conectando. Les pedimos disculpas por el retraso y los problemas técnicos que hemos tenido, pero es un gusto recibirlos tanto a Francisco, el director de esta diplomatura por 4 años consecutivos, como a todos ustedes y especialmente a Peter Roberts, con quien contamos hoy como guest speaker. Estamos desde la sede de Buenos Aires, transmitiendo en directo después de estos pequeños problemas técnicos que hemos tenido. Pero bueno, quiero primero presentar, como tenemos gente que no es de diplomatura, ya que esta es una clase abierta, quiero presentarles a Francisco Romano. Ustedes saben que Francisco es el director de la diplomatura de hidrocarburos de la Universidad de Austral, pero también es vicedirector del instituto y codirector del Instituto de Energía, también de la Universidad de Austral. Él es director de AIEN, que es el ex AIPN, y también es socio del estudio Pérez Salati, Grondona, Benítez y Arsen. Bueno, como esta es una clase abierta al público, lo que vamos a hacer es, vamos a tener la siguiente modalidad. Va a hablar Francisco muy brevemente, luego va a hablar Peter, que va a hacer su exposición toda en inglés, y vamos a tomar preguntas al final. Entonces vamos a tomar las preguntas por el chat y luego vamos a hacer esas preguntas. Las preguntas las pueden escribir en castellano o en inglés, como ustedes se sienten más cómodos. Pero las preguntas las vamos a hacer al final y les pedimos que por favor las escriben desde el chat. Okay, so now I'm going to switch into English. Hello everyone, I'm going to welcome very warmly Peter Roberts. You know that Peter, our keynote speaker today, is a well-known scholar and also very seasoned practitioner, experienced in oil and gas projects. His book on JOAS, Joint Operating Agreements, is a must. And most of all, we want to highlight Peter's generosity by giving this lecture and by waiting so long today, okay? So without further ado, I give you Francisco Romano and Peter Roberts. I'm Consuelo, and I'm going to be assisting in anything that you may need, both speakers and attendance. Okay, thank you.
Okay, thank you very much, Consuelo. I had prepared some words, but I'm not going to make that because we are late already. So thank you all for waiting, and thank you, Peter, for helping us supporting this diploma in hydrocarbons law once more. Please start your presentation. Thanks.
Okay, thank you. Thank you, everybody. Hopefully you can see my slides. Yeah?
Yes.
Very good. Very good. So what I will do is give you a quick update on things that have happened in joint operating agreements, unitization, unit operating agreements, and farm-out agreements recently. I know you've done courses on JOAs, UOAs, and FOAs. So you do know the basics. So this will just be a top-up session to explain some things which I've seen happening. On JOAs, there's a few cases that we need to be aware of have come up now, some litigation. We have a case here from Canada, MEG against Connexus, and these are the facts of it. They're very straightforward. One of the things you have to do with the joint operating agreement is be very clear on what the scope of the joint venture is, and that's pretty straightforward. It's obvious, it should be simple to do, And in this particular joint venture agreement about pipelines, which pipelines the JOA related to. And it went to court in the end. And it went up to the Alberta Court of Appeal, and the court simply said, this pipeline agreement that contained some decisions about the second phase construction of the pipeline, and some of the details about this second phase weren't defined in the agreement. So it's absolutely crazy. But these guys, Meg and Connexus, had a pipeline joint venture agreement, and they didn't say what the scope of it was. So simple thing, when you're drafting a JOA, always get the scope put into the agreement properly. We've got an American case now, came up in Texas last year, EBX against operations. And it's a simple fact-based thing, but it's incredible where it went wrong and why this ended up in court. There were joint development agreements prior to joint operating agreements, and then the operator had to issue an authorization for expenditure and AFE to the parties, and the non-operators sued the operator under the JOA. They claimed that the operator did not have the right to recover certain costs, which it had cash called against the parties, and the court agreed. The court said that's absolutely right. The operator had no authority to cash call the parties because they had elected not to participate in a certain part of the JOA. And again, you read the facts of this case, the reference is up there, you can find it on the internet, very simple, and yet the operator just breached the JOA and went to court and lost. It's incredible that this stuff still happens. We go back to Canada for another one now. This is ENA Plus against Orlen. This is from last year, which was payable by three companies. And one of the three companies, the operator, Orlen, said, we will do an exclusive operation. And the other two parties decided not to participate in it. And the royalty holder, ENA Plus, sued all three parties, claiming it was owed a royalty on the full value of petroleum production. And the court said, no way, this is how exclusive operations work. Harvest had said, we're not participating in the exclusive operation. And there's no implied obligation of a producer to have to participate. So this case is a very good example of how an exclusive operations clause worked under a JOA. Again, but this next case is the most interesting one. Apache against Castex, another Texas case from last year. Lots of disputes between Castex about drilling and expanding facilities. And what happened was that Castex sued the operator, Apache, under the JOA, said that Apache had conducted willful misconduct, which is always very difficult to prove under a JOA. And the court upheld this and said, that's absolutely right. Apache has committed willful misconduct. And so what we now have is a US, a Texas state court, appeals court decision describes willful misconduct under Texas law as deliberate mismanagement without regard for the consequences. But you don't have to prove out this, that the Texas law definition of willful misconduct is now virtually identical to the English law definition of gross negligence. So these two definitions are evolving all of the time in these cases, and it was always rare that in a dispute you would find an operator guilty of willful misconduct, but this has happened here now. And so this is a good Texas law definition of willful misconduct, which is interesting to see. Those of you who are members of the AIPN know that they are updating the 2012 Model Form Joint Operating Agreement. It's still in development. It's been in development for 3 years now, and the plan is to release the new JOA in the third quarter of this year. What has changed in this new JOA? Some things. There will be a whole new section on economic sanctions law, and sanctions are very relevant now because of what we're seeing with Russia. So if the operator or a party cannot comply with the terms of the JOA, because to do so would put the operator or that party in breach of an economic sanctions law, they will be forgiven from doing so. And critically, if a party defaults on a cash call because it says I can't pay because to pay would put me in breach of sanctions, there will not be a default remedy under the JOA. And the operator has to comply with sanctions law, and the operator can be removed if it breaches sanctions law, and each party will give warranties and indemnities against breach of economic sanctions law. This is a whole new area in this JOA, so it's going to be very interesting to see how it develops. Another new topic, hot topic, this one in the newspapers all the time, greenhouse gas, to reduce greenhouse gas emissions from the operations, and the operator has an obligation to report greenhouse gas emissions profiles from the joint venture to the parties. We've never seen this in JOAs, but this will be new. So will this one, human rights principles, modern slavery is sometimes called. The operator will be under an obligation not to breach human rights principles, and parties will have to comply with that. So we're seeing all new things now coming in this JOA. When it eventually comes out this year, we will see more on decommissioning, because there's a lot more decommissioning going on. There is the definition of consequential loss in the JOA. The operator is not liable for breach of the JOA, and definitely won't be liable for consequential loss. The definition of consequential loss in the AIPN model form will move to the English law position. It's very, very similar. And the last big change is that when the operator arranges insurance of the joint venture, it will have to do so through insurance companies which have a certain credit support rating. It can't just be any insurance company. So we will see a lot of changes in this new JOA when it comes out this year. And then the things I'm seeing outside of the AIPN, JOAs, emerging trends, again, more on greenhouse gases, and that's consistent with the AIPN JOA. So there's a lot more about greenhouse, environmental, social governance, and arguments about whose standards, whose ESG standards should prevail. Should it be the operator, each non-operator, the state? But ESG is becoming very, very prominent now. More in JOAs to reflect this emerging energy transition and the idea that companies would be giving up on oil and gas exploration and production. So more reservation around withdrawal rights, the ability of a party to walk away and to give collateral support for its operations and decommissioning costs. And then, interestingly, modifying JOAs now to cover hydrogen production and transportation. People thinking, how will I make hydrogen? How will I transport hydrogen? Can I use a JOA for hydrogen? And we're still waiting to see an established industry hydrogen sales contract. There are various private forms being used, but I think we're going to see more about JOAs governing hydrogen. And I call it the AIPN. Of course, it's changed its name recently. Francisco is a director to the AIEN, so the Association of International Energy Negotiators. And this emphasizes the move towards hydrogen and the use of the JOA for hydrogen production. So quite a lot of stuff going on with JOAs, litigation about the clauses to the JOAs coming, the AIPN model form and other industry standards. So some things to look out for there. Unitization, there's something which is, two things are happening, and I'll explain it through this slide. Now, in English, the idiom is that the tail is wagging the dog, and this is the nearest I could get to a Spanish approximation of it. But what's happening is, on unitization now, some companies are causing huge problems. And we're going now to Cyprus and Israel. And there's a block here. You can see in the middle of these two separate maps called Aphrodite. And Aphrodite is a gas field which sits in block 12 offshore Cyprus. And a tiny, tiny part of it sits in Israeli waters. And if I show you, this is a map which suggests that there's a lot more of the Aphrodite block on the Israeli side. So people draw these maps according to their commercial or political preferences. But the Aphrodite block sits in block 12 of Cyprus, and a tiny, tiny amount sits inside Israeli waters. And I speak to some Israelis about this and find out what's going on. So on Aphrodite, the field sits in Cyprus block 12 and the Ishai block on the Israeli side. And this has been around for a long time. More than 10 years ago now, a delimitation agreement was signed between the two governments to develop the field. Nothing has happened with it since then. It's been very slow. In 2013, the Israeli partners drilled a well 1 kilometre from the boundary with Cyprus, which showed gas, but not much, not marketable quantities of gas. But 2 years later, the Israeli government approved Ishai side as a separate gas discovery. And this is where the issue has come now about the need to unitize it. The estimates are there's 120 billion cubic meters of gas on the Cyprus side, and anything between 1 and 12 billion cubic meters of gas on the Israeli side, which is anything between 1% or 10% of the total field. So the Israeli side is really, really small, but the Cyprus government is unhappy that unitization will slow it up. So in 2021, only last year, there was another state framework agreement signed between the two agreements, and it was left to the companies on each side to sort out how to develop the Aphrodite field. Nothing has happened again. The Cyprus government is desperate to develop Block 12 because it's the country's largest offshore gas discovery, and they will drill a production well this year, and they plan to have the block in production in 2023. And they're ignoring the Israeli side of it. And what we are probably going to get is international arbitration between the two countries to determine whether this block should be unitized or not. And all the speculation is that we will see payment of agreed compensation to Israel. So the Israeli partners. But this is an example of a very small tail, which is the Israeli side, wagging a very big dog, which is the Cyprus side. And it doesn't just stop there. If we go to Ghana now, there's a really interesting project going on in Ghana. So ENI, the Italians, they hold the offshore Cape 3 Points block. And this contains a field producing oil and gas, Sankofa, and it's been producing for 5 years now. Significant production, 50,000 barrels a day. And if I go back up to this map, Springfield, a little Ghanaian company called Springfield, holds the next door block, West Cape 3 Points, and it contains a discovery called Athena, which was made in 2019. In April 2020, Ghana's Minister for Energy said that the Sankofa and Athena fields had identical properties and issued a directive under the regulations calling for a unitization of the two deposits together. Now, Sankofa has been producing 50,000 barrels a day for 5 years. Athena is just a discovery and it hasn't produced anything. And if you're ENI, you're going to be very unhappy with having to unitize your field, the big dog, for the small tail, which is Athena. And this one it's gone mad. What's happening now? So the directive ordered ENI and Springfield to unitize unitized the two fields and said you've got until September 2020. ENI says that the Athena discovery is not producible, it's not commercial, and shouldn't be unitized with their big producing field. Last year, more than a year of no progress, Springfield went to court in Ghana, and the court ordered 30% of all the revenues from Sankofa to be held in escrow field with World Bank finance behind it. So putting 30% of the revenues in escrow has really messed with the economics of the development. I mean, E&I have been very, very unhappy about this. So last year they filed a suit at the London Court of International Arbitration in London to challenge the unitisation directive. And E&I has taken Ghana National Petroleum Corporation. The unitisation is a breach of contract. It's a breach of their petroleum agreement, implement the unitisation, and it's sued ENI has sued the Ghanaian government for damages. And so Springfield thought it was going to have a unitisation. Now the Ghana government has gone to arbitration in London, and ENI have made this very, very public. And I spoke to some lawyers recently who were working on this, and they said that the Ghana government is very unhappy about this because it's very bad for investment in the country, but there is now a very public dispute about the application of unitisation. Now, there are lots of other unitisations, domestic and cross-border, going on around the world all the time without too much excitement. But the two examples here we have here, Aphrodite and then the Springfield one in Ghana, show where a situation where a company which has a very, very small interest can completely destroy the operation of a much wider interest, and it defeats the purpose of unitisation, which is supposed to be a harmonious joint development, and it turns into a big problem. So we will watch this one, watch Aphrodite and watch this Springfield one. They'll be in the news all the time now, and it will be interesting to see whether we have forced unitisation or whether it gets dropped and compensation payments get paid instead. So that's a topical thing that's happening there. And then on farm-out agreements, there's been some excitement here. If we just remind ourselves, it's the relationship between the farm-out agreement and the joint operating agreement that's critical here. And we can have a situation where a JOA comes into existence after a farm-out agreement has been signed. And so this is the situation here where A co farms out to B co, and then after the event, they agree a joint operating agreement. Or we can have a situation where there is already a JOA in existence, and then after the farm out, you still got the same JOA, but it already applied. And so the issue you have here is you'll have a farm out agreement and a JOA side by side. And this will cause problems if you don't harmonize the terms of the farm out agreement and the JOA. And it went to court in the UK. So we had this case in 2020. So in Apache North Sea against Uroil, there was a dispute between the parties. There was a farm out agreement and a JOA. And the JOA, everybody agreed, was in existence at the time of the farm out agreement. And there was a clause which said if there is a conflict between the words of the two agreements, the terms of the JOA would prevail. And there ought to be no conflict because the farm out agreement is about farming out and the JOA is about operations. But there was a dispute, and it related to how much costs Apache, the operator, was allowed to charge for the hire of a drilling rig, which it had contracted to drill an exploration well. And Apache had contracted a drilling well at a time of high market rates, and it wanted to pass those high market rates back to Uroil under the farm out agreement. So Apache said it should be allowed to charge actual higher costs, which would do under the drilling contract. In contrast, URoyal, the other party, argued that the accounting to the JOA would apply, and the accounting procedure had a clause in there which said that effectively Apache had to apply market rates, not existing contract rates, and prevailing market rates had dropped. They were 3/4 less than the amount which Apache was looking to charge. URoyal was successful at first instance in London, and it went to the Court of Appeal, and the Court of Appeal held the judgment up. And what courts have decided here is that limitations on the quantum of the costs which Apache, the operator, should be able to recover were created in the JOA, and they applied to condition the farm-out agreement. So this is a good example of a case where people drafted a farm-out agreement and ignored the JOA, but the terms of the JOA changed the terms of the farm-out agreement. And it's a very good case study on how you must match up the two agreements side by side. And then if you are a student of farm-out agreements, if you find them interesting, if you go onto the AIEN, sorry, I'm old school, I call it AIPN, but if you go on the AIPN website, farm-out agreement, and it identifies the farm-out interests, it applies conditions precedent to the effectiveness of the transfer under the farm-out, and it provides for the payment of cash consideration and carry costs. On the same website, 1 year later, you find a Model Form International Asset Sale and Purchase Agreement. And guess what? It identifies the purchase interests, it applies conditions precedent to the effectiveness of the transfer, and it provides for the payment of cash consideration. It does exactly the same thing as the farm-out agreement. So you have a farm-out agreement and a sale and purchase agreement. The only difference between the two is that the farm-out agreement is for future carry costs, whereas the asset sale and purchase agreement is typically for historical costs. Even AIPN recognizes that this is a problem. So what they say is that the model form asset sale and purchase agreement is quite similar to, but it's slightly different to the model farm-out agreement as well. And it doesn't give you much guidance, because what they say is you should compare the two and consult and use the farm-out agreement if there is a structure of funding the performance of services or specific work obligations. My advice to anybody wondering which agreement should I use, the farm-out agreement or the asset sale and purchase agreement, is only use the farm-out agreement if you plan to unwind the assignment under the farm-out further down the road. So if the farmie doesn't pay the carry costs and you need to have a complete unwind and move everything back to how it was, you must use the farm-out agreement. And there is no rewind mechanism in the sale and purchase agreement. So if you do this, you've got a problem. You go backwards. And I'm mindful of the time because I don't want to chew up too much of your time because you might have questions. But that was all I was going to say by way of an update on what's happening with JOA's unitization agreements and farm-out agreements. You've got the slides, and I was going to say, if you've got any questions now, I'll be happy to address them, or Francisco knows how to get hold of me. If you've got any questions, you can email them through to me and I'll be happy to answer them. So I'm going to pause there and give you a chance to get your breath back. Francisco, over to you.
Thank you very much. Excellent updates, Peter. While people think there are questions, let me make a question myself. We studied at the diploma the rule of capture, the famous rule of capture for unitization. Would you say that this directive from the Ghana government goes against the rule of capture?
Yes, I would. I think it definitely does. And I think the Ghana case is that the small party, Springfield, was nervous that the big party, ENI, would drain all of the field. And so that's why they went to see the government and said, could you please issue an order forcing them to unitize it because we're worried about the law of capture. Now, so I think the law of capture works well in onshore United States, and it's just bad luck, but unless you get a forced unitization. But I think here, what's happened in Ghana is completely opposed to the law of capture, or it could be.
Agreed. Yeah. And in the case of Israel, and that was very, very interesting. I wasn't aware of that case, Cyprus and Israel. In that case,
Yeah.
would you say it would be retroactive? So the unitization effects would be retroactive, or the compensation in money rather than unitization, would that be retroactive, and how is that determined?
Yeah, and so I think it won't be retroactive in Israel, Cyprus, Aphrodite, because they have not yet started production from the Cyprus side.
Okay, okay.
But I think that the big problem of retrospective adjustment is Ghana, because Sankofa has been, so if Springfield wins the case, if they win their argument, they will say, I have 10% of the field which has been producing for 5 years. So you owe me 5 years of revenues times 10%, and that will be a retrospective cash adjustment.
Mm-hmm.
And that will be a huge amount of money.
Mm-hmm, mm-hmm. And then on the Eurail case, we studied that case in class, and it was very puzzling for everyone because it creates some weird connections between the Farmout and the joint operating agreement. And in that case, we studied it in detail, and apparently the operator had already an agreement in place, which was much more expensive than the market value for contracts. And yet they wanted to impose that on the smaller party. And in the middle, they brought some new party in. So they got majority and went ahead with the payment and with the AFE. But the other party, the plaintiff in the case, rejected the AFE. Do you think this is a clear-cut case and solution, or would you say it isn't so easy to resolve?
I think that the only lesson from Uroil is Apache is, when you do a farm out agreement, put all of your terms in the farm out agreement with the JOA. And I think it was a bad farm out agreement. It was lazy.
Yeah, yeah. Okay.
Get good lawyers. That's the only answer.
Let's see, any questions from the public, from the audience? Well, apparently not. I'm sure.
Well, no problem. No problem, because if anybody's got any questions,
we will all
just email me. That's no problem.
Sure, sure. We will read this in detail and profit from the insights. Of course, I don't know if you want to add anything or.
No, I've got nothing else to add. Only to say I'm working this week in the lovely city of Torun. If anybody has ever been to the north of Poland, and it's a very beautiful medieval city. And I am now going to go and have a beer in all of your honor.
Oh, great. So, cheers. Thank you very much, Peter.
Hello. Take care, everybody.
Thank you.
Cheers. Bye-bye.
Bye-bye.